but he's not unmuted himself. Yeah. Good evening, friends. Mr. Murthy D. Naik is on our platform earlier also, and on different spectrums of, especially on the perspectives of criminal jurisprudence, he has shared his knowledge. And those who have missed that, they can always watch those sessions. There was always a request to the effect that there have been an umpteen number of judgments by the Honorable Supreme Court in the criminal jurisprudence. And therefore, we thought, why not have a bird-eye view in 1 hour session, just like what they said, news in quick shots. So we will be touching around 15 judgments, but laying down the broader contours. And as if the viewers find it good, we can have a one particular or another judgment which can be written on the chat to the effect that which judgment has to be explained in extension. That is the per se discussion between me and Mr. Murthy as well as Trivikram, that we can take that particular judgment for a larger discussion and larger principles, because today is you can say more like a trailer. The movie can be watched at a later point of time. And thank you, Mr. Murthy. And we are glad that you have recovered in health also, and you're more healthier also. Healthier in the sense, healthy body. Healthy part goes to me. Okay. And thank you, and over to you.
Yeah, good evening, everyone. After a long time, I'm back on Vikas D's platform, that is Beyond Law CLC. I think this is the 5th year that Vikas D has consistently made it a point to live stream. 6th year. Sorry, I stand corrected. Oh, so it is 6 years since the corona hit us. So consistently he has been having these sessions on a regular basis, which is a very Herculean task. And he was requesting me for quite some time, but due to one reason or the other, I could not make it. And finally, I had to give in and agree to speak on the platform today evening. So we chose a very different topic. Instead of concentrating on one particular topic, I suggested to him that I will cover around 15 judgments of the Honorable Supreme Court on important judgments of the Honorable Supreme Court on criminal law, so that the viewers can have, as put by Mr. Vikas, a bird's eye view of the various law laid down in 25 and 26. So coming straight to the topic, the first judgment which I have handpicked is Directorate of Revenue Intelligence versus Rajkumar Arora and others. That is 2026, Volume 2, SEC 401. This deals with the aspect of whether a charge can be deleted under the garb of Section 216 of CRPC. The Honorable Supreme Court has held, in fact, that is the consistent law also, that charge cannot be deleted altogether. Only it can be altered or added. In fact, paragraph 178 of the report, of the SEC report, would be relevant for the benefit of the viewers. I am just pointing out paragraph 178. Once again, I will repeat the citation: 2026 to SEC 401, Directorate of Revenue Intelligence versus Rajkumar Arora and others. In fact, the Supreme Court has consistently held that alteration of charge means adding an additional charge. It does not mean deletion of a charge that has been already framed. So under the garb of alteration of charge, a charge cannot be deleted. Now the next judgment, important judgment, which according to me is that of Kumari Shubha alias Shubha Shankar versus State of Karnataka and another, reported as 2025 SCC Online SC 1426. This is a very interesting judgment which arose from my High Court. This was a SLP before the Supreme Court, an appeal before the Supreme Court arising from a concurrent finding of conviction and sentence of imprisonment for life arising out of a murder case. Here, the Supreme Court, while confirming the conviction for murder, has adopted a slightly interesting approach. It has given the appellants, convicts, the right to seek pardon within 8 weeks from the date of pronouncement of the judgment. This emanates from a love triangle between the main accused, that is the girl and her boyfriend, and they conspire with other two people, the hitmen, and they murder the fiancée of the girl. So the Supreme Court has held that it was a murder committed. A very interesting word has been used. They say that in paragraph 100, the appellants who committed the offense with adrenaline pumping in their veins have now reached the middle age. Two out of the four accused persons were teenagers, etc., etc. In the light of the same, we would like to facilitate the appellant's right to seek pardon by permitting them to file appropriate petitions before His Excellency the Honorable Governor of Karnataka. We would only request the constitutional authority to consider the same, which we hope and trust would be done by taking note of the relevant circumstances governing the case. Accordingly, we grant 8 weeks' time from the date of this judgment for the appellants to file appropriate petitions seeking to invoke the power of pardon under Article 161 of the Constitution. Till these petitions are duly considered and decided, the appellants shall not be arrested and their sentence shall remain suspended. The appellants were on bail during the pendency of the appeal before the Supreme Court. Hence, as a special case, this order has been passed and opportunity has been given to the appellants to approach the governor. Though right to approach the governor and seek pardon is a constitutional right, a specific liberty has been reserved by the Supreme Court. Now, the third judgment would be Pradeep Kumar Kesarwani versus State of Uttar Pradesh and another. This deals with frivolous or vexatious proceedings. The Supreme Court has held that this is again a reiteration in frivolous or vexatious proceedings. The court owes a duty to look into many other attending circumstances emerging therefrom. Emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under Section 482 of the CRPC or Article 226 of the Constitution, need not restrict itself only to the stage of a case, but is empowered to take into account the overall circumstances leading to initiation, registration of the case, as well as materials collected in the course of investigation. This read between the lines was coined in the case of Muhammad Wajid versus State of UP. So the Honorable Supreme Court has culled out the relevant paragraph of Muhammad Wajid, which was reported as 2023 SEC Online SC 951, in this case of Pradeep Kumar Kesarwani, which is reported as 2025 SEC Online SC 1947. So while arguing a matter for quashment, either under Article 226 of the Constitution or 482 of CRPC, that is the present 528 of BNSS, the advocates can make use of this judgment, wherein this between the lines means, according to me, it would be other attending circumstances or other supporting circumstances which led to the filing of the criminal complaint. So, para 17 of the SEC report is relevant. Now, the fourth judgment is again on the point of 482, that is Imran Pratap Ghadi versus State of Gujarat. Here, the Honorable Supreme Court has dealt with Article 19, Article 12, 21, 51A, etc. and paragraph 47. That is, Imran Pratap Ghadi's judgment is reported as 2026 1 SEC 721. So, para 47 of the report is important. There they say that there is no absolute rule that when investigation is at nascent stage, the High Court cannot exercise its jurisdiction to quash an offence by exercising its jurisdiction under Article 226 of the Constitution of India or under 482, equivalent to Section 528 of BNSS, when the High Court in the given case finds that no offence was made out on the face of it to prevent abuse of process of law. It can always interfere even though the investigation is at the nascent stage. It all depends on the facts and circumstances of each case as well as the nature of offence. There is no such blanket rule putting an embargo on the powers of High Court to quash FIR only on the ground that the investigation was embargo on the powers of the High Court to quash FIR only on the ground that investigation was at a nascent stage. If such embargo is taken as an absolute rule, it will substantially curtail the powers of the High Court, which have been laid down and recognized by this court in State of Haryana versus Bhajan Lal. Then importance of freedom of expression and duty of courts, etc., has been culled out and comprehensively dealt with. Now, the fifth judgment would be that of Ashish Dave versus State of Rajasthan on the same lines. In fact, here the Honorable Supreme Court refers to Imran Pratap Ghadi in para 24 of Ashish Dave versus State of Rajasthan. This is, I don't have the reported judgment. This is SLP criminal number 19369 of 2025. Ashish Dave versus State of Rajasthan and another. Here the concept of preliminary inquiry, which is permissible, has been culled out and taken into consideration. Originally, the concept of preliminary inquiry was not available under 154 of CRPC. Now, 154 has become 173 of BNSS. And in paragraph 23, they have held the new regime under the BNSS specifically deals with such situations and provides an additional safeguard where the complaint is for offences carrying punishment between 3 to 7 years. Subsection 3 of Section 173 BNSS empowers the officer in charge of a police station with prior permission of a superior officer to conduct a preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in matter where the alleged offence is punishable with imprisonment for a term between 3 years and 7 years. For ease of reference, Section 173 BNSS is reproduced hereunder. In my opinion, this between 3 years and 7 years should be interpreted as any offence which is punishable up to 7 years. that does not mean an offense which is punishable up to 2 years should not be a preliminary inquiry should not be conducted into. That would be a misnomer. For some reason, the word between 3 and 7 years has been employed in 173(3) of BNSS. So any offense punishable up to 7 years will have to be in a preliminary inquiry will have to be conducted. So that would be the interpretation that one can reasonably apply to this provision. And while dealing with this, in paragraph 24 of Ashish, the way Imran Pratap Gadi has been called out. Now the next judgment would be 2026 SCC Online SC 162. This is Satyendra Kumar Until versus Central Bureau of Investigation and another, decided on January 15, 2026. Friends, as you all are aware, this Satyendra Kumar Until host of directions has been issued by the Honorable Supreme Court in the previous decisions on bail, right of bail, bail bond, etc., right to arrest, notice under 41A, etc., etc. Now, the provision of Section 35 of BNSS was considered. For the benefit of viewers, I would remind them that Section 35 of BNSS corresponds Section 41 of CRPC. Now, in this, para 26 and para 33 would be relevant. And in para 33 of this Until's judgment, host of directions have been given as far as arrest is concerned. In fact, the conclusion makes a very good read. Para 32, the power of arrest under section 35(6) read with 35(1)(b) of BNSS 2023 must be interpreted as a strict objective necessity and not a subjective convenience for the police officer. It does not mean the police officer can arrest to simply ask questions. However, it means that the police officer must satisfy himself that the investigation qua an offence punishable with imprisonment up to 7 years cannot proceed effectively without taking the concerned individual into custody. Any interpretation to the contrary would clearly frustrate the purpose and legislative intent of sections 35(1)(b) and 35(3) to 35(6) of the BNSS 2023. Para 33. On the basis of the interpretation given by us, we conclude as follows. An arrest by a police officer is a mere statutory discretion which facilitates him to conduct proper investigation in the form of collection of evidence and shall not be termed as mandatory. B. Consequently, the police officer shall ask himself the question as to whether an arrest is a necessity or not before undertaking the said exercise. For effecting an arrest, qua an offence punishable with imprisonment up to 7 years, the mandate of section 35(1)(b)(1) of BNSS 2023, along with any one of the conditions mentioned in section 35(1)(b)(2) of BNSS 2023 must be in existence. A notice under section 35(3) of the BNSS 2023 to an accused or any individual concerned qua offences punishable with imprisonment up to 7 years is the rule. even if the circumstances warranting an arrest of a person are available in terms of the conditions mentioned under Section 35 1B of BNSS 2023, the arrest shall not be undertaken unless it is absolutely warranted. Power of arrest under Section 35(6), read with 35 1B of the BNSS pursuant to a notice issued under Section 35(3) of BNSS is not a matter of routine but an exception, and the police officer is expected to be circumspect and slow in exercising the said power. So these directions are in addition to the directions already issued in the previous decisions of Satyendra Kumar until as far as arrest, etc. Basically, this judgment deals with the power of arrest, etc., and also the once again the Supreme Court has emphasized Article 21 and right of innocence, etc., of the accused person, and mechanical arrest has been deprecated. Now coming to the next judgment, this is Subelal versus State of Chhattisgarh, 2025 5 SCC 140. Here the Supreme Court was dealing with the question of bail under Section 437 and specifically 437(6) has been dealt with. It has been held that bail to accused under when trial does not conclude within a period of 60 days is not mandatory. Para 11 of the judgment is important. Now next would be Dr. Anand Rai versus State of Madhya Pradesh, 2026 SCC online SC 187. This is with regard to framing of charge. The Supreme Court has again highlighted that the framing of charge or hearing on discharge is not an idle formality, and the trial judge hearing the accused before charge or on discharge should be conscious of the fact that a charge should not be mechanically framed based on the police report filed by the police or on the complaint. Para 21. Before parting with the matter, it is observed that at the stage of framing of charge or considering discharge, the court is not dealing with an abstract legal exercise. It is dealing with real people, real anxieties, and the real weight of criminal prosecution. Judicial responsibility at this stage calls for care, balance, and an honest engagement with the facts on record. The power to frame a charge is not meant to be exercised by default or out of caution alone. When the materials placed before the court taken at face value does not disclose the ingredients of an offense, the law expects the court to have the clarity and courage to say so and to keep such a case aside. So the Supreme Court has used very strong words. It has said clarity and courage to say so. In fact, friends, as you are aware, right from L. Muniswamy's case 1977, which again arose from our High Court, the Honorable Supreme Court has time and again held that the framing of charge is not a mechanical exercise to be carried out by the trial judge, but there has to be sifting and weighing of the materials on record. And the trial judge should examine whether there exists sufficient material to frame charge against the accused. So then subsequently in Sajjan Kumar versus CBI, etc., the Supreme Court had dealt with. And once again, in the case of Dr. Anand Rai, that is 2026 SEC Online SC 187, the Supreme Court in paragraph 21 has used strong words so that the trial judges at least wake up now and start exercising their power of discharge, because I have seen they are very reluctant. At least in our trial courts in Karnataka, the trial judges are very reluctant. With lot of responsibility, I am making this statement. The power of discharge is not exercised by the trial judges at all. Unlike the judges in Delhi and Bombay, where they are courageous and have the clarity to exercise their power of discharge and to nip in the bud frivolous prosecution. Hopefully, the trial judges in Karnataka will start exercising their power of discharge. In fact, there have been certain amendments and certain additions under the BNSS. Under the old 239 of CRPC, there was no provision for examination of the accused, though the word examination was used. No trial judge exercised that power and called upon the accused to examine himself. Whereas in 261 of BNSS, it has been clarified where the examination is quite, I'm sorry, 263. 262 and 263 would be relevant. That is with regard to trial of warrant cases by magistrate. So the old 239 has become 262 and 263. In fact, in 262.2, if you would see, and for the benefit of viewers, I would read it. If upon considering the police report and the documents sent with it under section 193 and making such examination, if any, of the accused, either physically or through audio, video, electronic means, as the magistrate thinks necessary, and after giving the prosecution and the accused an opportunity of being heard, the magistrate considers the charge against the accused to be groundless, he shall discharge the accused and record his reasons for so doing. This portion of making such examination, if any, of the accused either physically or through audio, video, electronic means, as the magistrate thinks necessary, was not existing in the previous 239. Hence, there was a confusion, and our High Court, though I had argued that examination includes the examination of the accused at the stage when he argues for discharge, because that is the first available opportunity. Now that has been clarified. In spite of that, the trial judges are reluctant to exercise their powers as provided under the provision. And 227, that is discharge by a sessions court, has become 250 of BNSS. Trial before a court of sessions, that is envisaged under chapter 19 of BNSS, and that deals with 250. So these are the two relevant provisions of discharge. As far as discharge pertaining to warrant case, otherwise there on a police report, etc., the provision remains the same, because there it is slightly different way. In case of a in respect of a case arising out of a warrant trial, otherwise on a police report, then the complainant will have to lead evidence at the stage of framing of charge. That is the provision. That is the erstwhile 245, 246 of CRPC. That has now become 267 onwards of BNSS. Then, as you all know, as far as summons case is concerned, we have no provision of discharge at all. Now, the next judgment which I have, which according to me is important, is 2025 1 SEC 753. Tushar by Rajnikant by Shah versus Kamal Dayani and others. This is with regard to anticipatory bail under 438. It has been held that non-cooperation by the accused is one matter and the accused refusing to confess to the crime is another. There would be no obligation upon the accused that on being interrogated he must confess to the crime, and only thereafter would the IO be satisfied that the accused cooperated with the investigation. Moreover, any confession made by the accused before a police officer held is inadmissible in evidence and cannot even form a part of the record or the charge sheet. Because normally the prosecution has the tendency to argue that he is not cooperating with the investigation, especially when interim bail is granted and the petitioner has been asked to appear before the investigating officer. So, interpreting that, the Supreme Court has held that cooperating with the investigation does not mean that the accused has to, or the proposed accused has to confess to the crime. Participating in the investigation is sufficient and would fall within the ambit of cooperation with the investigation. Now, the 10th judgment would be Vihan Kumar versus State of Haryana. This emanates from an offence under the PMLA Act 2002. That is informing about the grounds of arrest. Here in the supplementing judgment of Justice Koteshwar Singh, he has in paragraph 41 has supplemented and held that the issue on the requirement of communication of grounds of arrest to the person arrested as mandated in Article 22(1) of the Constitution of India, which has also been incorporated in the PMLA and Section 19 thereof, has been succinctly reiterated in this judgment. The constitutional mandate of informing the grounds of arrest to the person arrested in writing has been explained in Pankaj Bansal so as to be meaningful to serve the intended purpose, which has been reiterated in Prabir Purkayastha. The said constitutional mandate has been reiterated in Prabir Purkayastha. The said constitutional mandate has been incorporated in the statute under Section 50 CRPC, that is Section 47 of BNSS. It may also be noted that the aforesaid provision of requirement of communicating the grounds of arrest to be purposeful is also required to be communicated to the friends, relatives, or such other persons of the accused as may be disclosed or nominated by the arrested person for the purpose of giving such information as provided in Section 50A CRPC. As may be noted, this is in addition of the requirement as provided in Section 50 subsection 1 of CRPC. So friends, Justice Koteshwar Singh has held that the friends and relatives should also be informed. In fact, in subsequently, the Supreme Court has reiterated this aspect in Mihir Rajesh Shah versus State of Maharashtra. So, as a corollary to Vian Kumar, you may also note 2026 1 SEC page 500, Mihir Rajesh Shah versus State of Maharashtra and another, which also emanated from PMLA 2002. The grounds of arrest to be communicated not only to the detainee stroke arrestee, but also to their friends, relatives, or any other nominated person. So Mihir Rajesh Shah, in Mihir Rajesh Shah, the Supreme Court has exhaustively explained the purpose of grounds of arrest. Of course, this grounds of arrest depends on case-to-case basis. It has been held that the grounds of non-supply of grounds of arrest should be urged at the first available opportunity. Recently, in that Sonam's case, that is that Meghalaya honeymoon murder, the Supreme Court has taken a different view, and also another case which arose from our High Court. In Darshan's case, also the Supreme Court had taken a different view and had cancelled the bail granted by the High Court on the ground that grounds of arrest was not supplied to the accused. Both the cases, that is of Sonam Raghuvanshi and that of Darshan, arose from a murder case, and hence the Supreme Court held that the ground of non-supply of grounds of arrest should be urged at the first available opportunity. You cannot sleep over the matter, argue for bail on merits, and then, as an alternative, at the third or fourth attempt, you cannot urge that ground. It has to be at the first available opportunity. Now, friends, the next important judgment delivered by the Supreme Court in 25 would be that of Arvind Kejriwal versus Directorate of Enforcement, again under the PMLA Act, and here the concept of grounds of arrest has been dealt with. The 13th judgment, according to me, delivered in 2026, or 13th judgment of today's discussion, is the 2026 judgment in the case of summoning advocates who give legal opinion or represent parties during investigation of cases and related issues in re. This is a suo motu case reported as 2026 2 SEC 233. 2026 Volume 2 SEC 233. The Supreme Court has taken into consideration Section 132 of the BNSS, which is pari materia to 126 of the Evidence Act, and has held that the provision provides or confers privilege on a client, obliging his advocate not to disclose any professional confidential communication. So the nature of the privilege has been elucidated in extenso in the said judgment. Then also rights under Articles 14 and 21 has been discussed, and it has been held that Article 14 and 21 encompass within it right to legal representation, legal aid, amicus, etc. So, in a nutshell, it has been held that a notice to an advocate who has provided legal advice to a party cannot be issued, and the advocate has the right to remain silent because it is the privilege of the client, obliging his advocate not to disclose any professional confidential communication. Then the next judgment is 2026-2 SCC 622. Om Prakash Ambadkar versus State of Maharashtra and others. Here, comparison of 156.3 CRPC and 175.3 of the BNSS has been made, wherein and under 156.3 3 CRPC provided for ordering investigation, but there is a slight addition under 175.3. There are two prerequisites under 175.3 before under 175 before an order under 175.3 of BNSS is passed, and that is under 175.4. And the Supreme Court says that the before ordering any investigation, 175.4 should be complied with. That is, a report should be received containing facts and circumstances of the incident, etc., after consideration of the assertions made by the public servant as to the situation that led to the incident so alleged, etc. So you may kindly look up 175.4. So this distinction has been considered in this judgment of Om Prakash Ambadkar, that is 2026-2 SCC 622. Then I have already discussed about Mihir Rajesh Shah, that is 2026-1 SCC 500, which reiterates the earlier judgment on grounds of arrest, etc. Then lastly, another judgment of 2025, that is Sarla Gupta versus ED, 2025 7 SEC 626. Here, this was a case where the Supreme Court was considering the aspect of whether a section application under 91 of CRPC can be filed at the stage of bail. Consideration of a bail application for an offense under the Prevention of Money Laundering Act. The Supreme Court has held that because Section 3 of the Prevention of Money Laundering Act mandates that that the burden is on the accused at the stage of bail itself to prove that he has not committed any offense. So it would be within his right to file an application under 91 CRPC and to request the Enforcement Directorate to provide those documents which are not part of the record. So it has been held that while hearing of a bail application, accused liable to satisfy the special court as to existence of a reasonable grounds for believing that he may not be guilty of offense under Section 3 of PMLA. This held an extraordinary and standalone provision which puts the burden on the accused at the stage of seeking bail. Therefore, while hearing a bail application, accused held must be allowed to invoke the provision of 91 CRPC for seeking production of the documents not relied upon by the ED. Denial of such right held will amount to a violation of his rights guaranteed under Article 21 of the Constitution. So this is what the Supreme Court has held. So with this, around 15, I have covered 15 judgments spread over the entire year of 2025 and first 6 months of 2026. Yeah, Vikas ji, over to you.
So Murthy Ji, I think we will not take any questions on this session because it's already substantiated, and as such we are not dwelling on this. I'll ask if Trivikram can chip in few words.
Yeah, I have specifically highlighted the relevant paragraph so that it would be easy for the viewers.
What you do is just share that particular note. I'll post it on the website.
Okay, I think the viewers were making a note of it, but however, I will ask my colleague to send it to you.
Yeah. So thank you. And tomorrow we will be doing a session on Stamp Act. That will be by Mr. KBS Sidhu, a former Chief Secretary, a former Additional Chief Secretary of Punjab. Thank you, everyone.